Hello and welcome to the San Diego SHRM Quarterly Employment Law Update. This is your Quarter 2 update for 2016. I am Christine Mueller, the Vice President of Legislation for San Diego SHRM. Today I am pleased to highlight for you some pending California legislation that is part of our advocacy efforts, the new California minimum wage law, some federal and state agency activities, some case law developments on disability discrimination and seating in the workplace, and some other issues that we are watching. Let's start with a few pending bills that we are watching closely as they move through the legislative process. In case you didn't know, each year your San Diego SHRM Legislation Committee identifies a few bills that are of particular interest to HR professionals and businesses in San Diego, and we act as a resource for Senate and Assembly members as they consider the proposed laws. There are 3 bills that SDSHRM has taken a formal position on this year, and the Legislation Committee has been meeting with state representatives locally and in Sacramento to discuss these issues and their impact on the HR community. The first of these bills is SB 985, the Workplace Flexibility Act, which SDSHRM supports. This bill would permit a non-exempt employee to request a work week of 4 10-hour days without the need for daily overtime. Currently, if employees and their companies want to arrange for a flexible schedule like this, they need to complete a very technical and complicated alternative workweek election process, which actually deters many employers from even offering alternative work weeks. We believe that this bill would provide much needed flexibility for both employers and employees. The second bill, which SDSHRM also supports, is AB 1383, which provides for a voluntary veterans preference in hiring decisions. Under this proposed legislation, employers would be able, if they choose, to grant a veteran a hiring preference without violating equal employment laws. Current laws only permit businesses to create a hiring preference for Vietnam War-era veterans. So we believe that this is a necessary update, and it would be a fair approach to addressing the high unemployment rate for veterans. And finally, SDSHRM has taken a position opposing AB 1676, the Salary Information Bill. This pending legislation would prevent employers from seeking salary history information from job applicants. We oppose this bill because we believe that employers should be able to rely on salary history when deciding whether or not an applicant is a good fit for the job. We will continue to watch each of these bills very closely. Let's move on from pending legislation and discuss a new law that was passed here in California. A deal was reached by Governor Brown and state legislators to raise California's minimum wage in increments each year beginning January 1, 2017. The increases will go into effect 1 year later in 2018 for companies with 25 or fewer employees. The governor may choose to temporarily suspend any scheduled increase if certain economy or budget conditions are met, but these increases are expected to occur. And remember that as the minimum wage increases, the salary basis test for California exempt classifications also increases. So make sure that your exempt employees still meet the minimum salary threshold. Next, let's take a look at some activity at the federal and state agency level. The EEOC has been going digital with the implementation of the respondent portal and now the launch of an online tool which enables parties to check on the status of the charge and communicate with the EEOC. Once a charge is filed, the EEOC will send an email with the instructions to the responding party about how to log onto the system so that a response can be filed. The EEOC also implemented new procedures for position statements that have many HR professionals rethinking the way that they prepare those position statements. Under the new procedures, the EEOC will release a company's position statement and non-confidential attachments to a charging party or his or her attorney upon request. but the EEOC will not provide the charging party's response or rebuttal information to the company. Because of this, many practitioners are scaling back on the analysis and details in their position statements so that the charging party or his or her attorney do not use the information in the position statement to prepare their litigation strategy. It is best to stick to the facts. If you rely on confidential information in responding to an EEOC charge, for example, if the information contains social security numbers or medical information or salary or financial data, it should be provided in a separately labeled confidential attachment with an explanation of why you believe the information is confidential. Here in California, the Fair Employment and Housing Council issued FEHA regulations mandating that employers must develop written anti-discrimination and harassment policies that meet detailed requirements. Among other things, the regulations require that policies list all protected categories under California law, provide instructions to supervisors to report misconduct, provide details about complaint mechanisms and investigations, and contain an anti-retaliation statement. The new regulations also provide how the written policies should be distributed to employees. Employers should review and update their anti-discrimination and harassment policies, ensure that proper complaint and investigation procedures are in place, and train human resources personnel on these new regulations and updated policies. Employers are encouraged to consult with Employment Counsel to ensure that their policies are in compliance. The DFEH also recently issued guidance regarding transgender employees, which can be found on the DFEH website. Their guidelines provide an explanation of the different types of gender transition and clarify that a transgender person does not need to complete any particular step in a transition to be protected by California law. The guidance also states that transgender employees have the right to use a restroom that corresponds to their gender identity rather than their birth sex. Moving on to some recent judicial decisions, California courts have given us guidance on disability discrimination issues. The first case that we will discuss is Wallace versus County of Stanislaus, out of a California appellate court. In that case, the employee worked as a bailiff and sustained a knee injury. His doctor indicated that he had some physical limitations, but the employee stated that he was okay to perform his job. The employer, however, believed that the physical limitations meant that the employee could not safely do his work as a bailiff and put him on an unpaid leave of absence because he had no paid leave available. The employee sued for disability discrimination, and a jury found that the employer was wrong. The employee could, in fact, perform the essential functions of his job. So the employer argued that it should not be liable because it had no ill intent toward the employee. It merely misinterpreted the doctor's note. But the court disagreed, reasoning that ill will is not a requirement for a disability discrimination case. Even though the employer had no ill intent, it was liable for disability discrimination. Based on this case, employers need to be cautious if they disagree with an employee's assertion that he or she is able to perform the essential functions of a job. If the employer is mistaken and prevents the employee from working, it could be liable for discrimination. A California appellate court gave us another interesting decision on disability discrimination, this time in the context of associational disability. In an associational disability case, the employee himself does not have a medical condition. Rather, the employee is protected because he is associated with a disabled person. In Castro Ramirez versus Dependable Highway Express, the employee needed a modified work schedule so he could work an early shift and be home in time to provide dialysis for his son. That worked out fine until a new supervisor changed the schedule to a later shift. Because the employee was unable to work the new shift, he was fired, and he brought claims for disability discrimination and retaliation. The court allowed the employee to proceed with his claims, indicating that the employee's association with his disabled son could have been a substantial motivating factor in the termination of employment. According to the court, California law creates a duty to provide reasonable accommodations to an employee who is associated with a disabled person. This California decision is a departure from federal law, and it is unknown whether the case will survive further appeal, but it is a reminder to employers to engage in a thorough interactive process, even when an employee requests an accommodation to care for a family member, friend, or associate. The last case that we are going to discuss addresses seating in the workplace. Most California wage orders provide that employees shall be provided with suitable seats when the nature of the work reasonably permits the use of seats. In Kilby v. CVS Pharmacy, the Supreme Court of California, for the first time, provided an explanation of the meaning of this requirement. Employers need to take a look at the tasks performed at a given location in the worksite to determine if the nature of the work permits seating. For example, in a retail store, a checkout stand might be a given location where seating is reasonable, but the sales floor might be a separate given location where seating is not reasonable. A clerk might have the right to a seat at the checkout stand, but not while working on the sales floor. Employers also need to look at the totality of the circumstances, and if the employer argues that there is no suitable seat available, the burden is on the employer to prove it. In essence, a seat is required for employees when it would be reasonable to provide one. It is important to remember that these rules apply to all employees, whether disabled or not. In addition, employers must still take reasonable steps to accommodate employees with disabilities, even when the nature of the work at a given location in the worksite does not reasonably permit the use of seats. Legal claims regarding suitable seating are likely to increase as a result of this ruling. California employers should examine the job duties that are performed at particular work locations and determine if seats should be provided at those locations. Finally, let's talk about pending issues that are on the horizon. In addition to the bills that we discussed at the top of this presentation, the California legislature is considering a number of employment-related bills, including SB 1166, the New Parent Leave Act. This bill would require almost all employers to provide 12 weeks of job-protected parental leave. Following up last year's amendments to California's Equal Pay Act, the legislature is considering an expansion of the Equal Pay Act to target race and ethnicity-related wage differentials. And the legislature is considering an expansion of heat illness regulations, which currently regulate outdoor employees, to also apply to indoor employees. Your legislation committee is monitoring these and many other employment-related bills. San Diego SHRM is pleased to help keep you informed about issues that affect California employers. For more information on these and other legal topics, check out San Diego SHRM's newsletter, The Resource, at SDSHRM.org. That concludes our employment law update. Thanks for tuning in.